Greetings and welcome once again to Maxims of Law, Part 11. Let's begin. We left off last time on jurisdiction. So, jurisdiction. See also authority, judge, and judgment. A judicial act by a judge without jurisdiction is void, but a ministerial act from whomsoever proceeding may be ratified. So something in an administrative capacity may be ratified, but a judicial act without jurisdiction is void. It is the part of a good judge to enlarge or use liberally his remedial authority or jurisdiction. It is the part of a good judge to enlarge his remedial authority or jurisdiction. All right, we got Aaron in the house. Welcome. Indeed. All right. Jurisdiction of the principal matter extends to the accessory matter as well. So the principal and the accessory. Jurisdiction of one extends to the accessory. Statutes are confined to their own territory and have no extraterritorial effect. This is an important one to consider, that statutes are confined to their territory and have no extraterritorial effect. So this is your term to remember. Jurisdiction is a power introduced for the public good on account of the necessity of dispensing justice. So when we think about a power for the public good, it's because of a necessity of dispensing justice. So the need of justice is the root of the power for jurisdiction, and it's intended for a public good, right? That's on account of the necessity, the need of dispensing justice. Before we go any further, I just want to remind everybody that this is an entertainment broadcast, not to be used for any kind of professional, personal, legal, or lawful uses, not to be used for any kind of decisions to be made outside of this entertainment broadcast and for educational purposes only. Don't do this at home. Let's proceed. All right, let's see here. Next page. All right. Jurisdiction is the power to declare the law, and when it ceases to exist, the only function remaining to court is that of announcing the fact and dismissing the cause. You get this? Jurisdiction is the power to declare the law, and when it ceases to exist, that's jurisdiction, the only function remaining to the court is that of announcing the fact and dismissing the cause. Beautiful. This is a great one to remember for dismissals based on lack of jurisdiction. Every jurisdiction has its own bounds. Indeed. The grant of jurisdiction implies the grant of all powers necessary to its exercise. So you can't have jurisdiction without granting it powers to exercise that jurisdiction. He who has jurisdiction to loosen has jurisdiction to bind. Now, if you notice, these maxims continually expound and detail and expand on certain principles of each of the headlines here. For instance, jurisdiction for this. So they are intertwined in the way they restate certain elements, but in different ways and in different contexts. The order of things is confounded if everyone preserves not his jurisdiction. Whoever has an ordinary jurisdiction is ordinary of that place. as opposed to an extraordinary jurisdiction. One ought to be subject to the law of the place where he offends. And this gets down to territorial jurisdiction. All right, let's proceed. One who exercises jurisdiction out of his territory is not obeyed with impunity. So that means he who exercises judicial authority beyond his proper limits cannot be obeyed with safety. Get this one. He who exercises judicial authority beyond his proper limits cannot be obeyed with safety. This seems to allude to simulations of justice on the side of a road, perhaps. He who exercises judicial authority beyond his proper limits cannot be obeyed with safety. Decisions are, as it were, jurisdictions. Now that's interesting there to consider. Jurisdiction is the power of a court to apply the law and to enter and enforce judgment. All right, so that sums up jurisdiction rather well. And if anything else, we picked up a few gems out of this one here. All right, let's proceed to the next section, which is jury and jurors. Okay, let's see what we get going on with the jury and jurors. As the legal maxims go. Jurors ought to be neighbors of sufficient estate and free from suspicion. Juries are the judges of fact and law in American jurisprudence. Juries are the judges of fact and law in American jurisprudence. The decision of 12 good and upright men is thought by the common law to be the dictate of truth. Good and upright men. See these conditions we have here, just as juries are the judges of fact and law, not just judges of fact as they are in some situations, but in American jurisprudence, the juries are also the judges of law itself. The judges are only there as a referee. The decision of 12 good and upright men, remember, this is the condition of good and upright men, is thought by the common law to be the dictate of truth. A jury not ought to be harassed by laborers and expenses. But I guess they do reimburse your parking, from what I understand. As if that's any consolation. The administration of an oath is an indispensable requisite to the formation of a legal jury. Well, the administration of an oath. Interesting there. All right. The verdict of a jury is a bar to equity. There could be no valid trial jury of less than 12 men, and a consent, even by the defendant, to a trial by a less number is absolutely void. The verdict of a jury is, as it were, the dictum of truth, even as the judgment of the court is the dictum of law. So this is something to be contrasted with the other one we had. I'm going to have to zoom up to that one here, which was this one here. Juries are the judges of fact and law, whereas here we're saying, I'm not going to both fit on the screen there, but the verdict of a jury is, as it were, the dictum of truth, even as the judgment of the court is the dictum of law. So for further research, interesting points here, but we're on to the next topic, which is justice. See also equity, law, and truth. Every presumption of the law must be in aid of justice. What is just and right is the law of laws. It is not just and right that he who exposes the faults of a guilty person should be condemned on that account, for it is the proper and expedient that the offense of the guilty should be known. So, as we would expect, it is not just and right that he exposes the faults of a guilty person should be condemned on that account, for it is proper and expedient that the offense of the guilty should be known. Now we come to a good one. Hasty justice is the stepmother of misfortune. Justice ought to be free, because nothing is more iniquitous than venal justice. Full, because justice ought to be halt, and speedy, because delay is a kind of denial. Boy, is a tongue twister here. So let's break this one down. Justice ought to be free, because nothing is more iniquitous than venal justice. So let's break this down a little bit here. We know what iniquitous is referring to the inequity, and of course justice is not supposed to be iniquitous. And let's see, we have venal, so this would be bribery. Let's see here. I've got a little corrupt, able to be bribed, involving bribery. Okay, that's it. Yep. A sin or offense as pardonable, excusable, not mortal. But we know that delay is a kind of denial. So this is another aspect of justice, that the delay is a denial of justice. Justice is neither to be denied nor delayed. Aha, another connection there. Okie doke. Justice is a steady and unceasing disposition to render to every man his due. Every man. Yeah, these are all great maxims. This is a great compilation. I've got quite I had a little glitch in the stream there. I have quite a few books on maxims, and this, to me, is the best and easiest to read collection of them, because they are translated very well into English for the ones that aren't originally in English. That justice which absolutely prevents a crime is better than that which severely punishes it. Note the operative word here, absolutely prevents. So without it absolutely preventing, it's not better than something necessarily that severely punishes it. The law favors justice and right. Justice is double, punishing severely and truly preventing, which takes us back to this maxim here. That justice which absolutely prevents a crime is better than that which severely punishes it. So we can see here that we could, by degree, see that truly preventing is better than severely punishing. Even though punishing severely is the first one listed, these are not in order of priority, according to this maxim. So this is why we have a great compilation here to think deeply into these and how they intertwine in a meaningful way to us interpreting the law. All right. Favor ought not to be able to bend justice, power to break it, nor money to corrupt it. For not only if it be overborne, But if it be abandoned or negligently observed, no one can think that he holds anything securely, or that he will inherit anything from his father, or be able to leave anything to his children. So, one more time. Favor ought not to be able to bend justice, power to break it, nor money to corrupt it. For, not only if it be overborne, but if it be abandoned or negligently observed, no one can think that it holds anything securely, or that he will inherit anything from his father, or be able to leave anything to his children. So here's an aspect of justice relating to posterity and inheritance. So that's another thing, is the security of holding and passing. Justice is excellent virtue and pleasing to the Most High. Justice knows not father nor mother. Justice looks at truth alone. The law does not fail in dispensing justice. Let right or justice be done, though the heavens should fall. And that comes from Black's Law, 2nd edition. Right, we're on to, it is the duty of a good judge to enlarge or extend justice. Now, we saw this one previously. Faith is the sister of justice. Wow. Justice is prior to liberty. Indeed. It is the property of a judge to administer justice, not to give it. Which is beautiful here. And back to this one here, that justice is prior to liberty. We consider liberty as basically government-sanctioned freedom. Without that justice, it can quickly degrade into tyranny or other forms of nefarious control. Let us proceed. We're on to knowledge and understanding. See also common knowledge and ignorance, which we've already gone over there. Discretion is to know through law what is just. By reasoning, we come to true reason. So you see the process to get to the truth. That which is necessarily understood is not wanting. That which is tacitly understood is not considered to be wanting. So that's what is needed to be understood is not wanting, and what is tacitly understood by practice, right, is not considered to be wanting. Nice distinction there. No one can properly understand one part before he has read through the whole, again and again. You will perceive many things much more easily by practice than by rules. The knowledge of smatters is mixed ignorance. Jurisprudence is the knowledge of things, divine and human, the science of the just and the unjust. He who questions well learns well. To know properly is to know a thing in its reason, and by its cause. We are truly said to know anything, where we know the true cause thereof. So, to know properly is to know a thing in its reason and by its cause. Cause and reason. We are truly said to know anything where we know the true cause thereof. Indeed, fear not, question everything. And let's proceed to some more of these maxims. We are ignorant of many things which would not be hidden from us if the reading of old authors was familiar to us. And that's what we're all doing here tonight. So salute to all of you here tonight. Although I know we have somewhat of a thin audience. Hopefully some more people will show up before we reach the end here and watch this on the replay too, hopefully. These kind of maxims really need to get out there a little bit more into the common knowledge, so to speak. Things universal are better known than things particular. To know a thing and to be bound to know it are regarded in law as equivalent. To know it and to be bound to know it are regarded in law as equivalent. This is another one important to know about duties. To know a thing and to be bound to know it are regarded in law as equivalent. To know the laws is not to observe their mere words, but their force and power. That is, the essential meaning in which their efficacy resides. Now that's a beautiful one there too. To know the laws is not to observe their mere words, but their force and power. That is, the essential meaning in which their efficacy resides. The law forces no one to make known what he is presumed not to know. Let everyone employ himself in what he knows. Inquire into doubtful points if you wish to understand the law well, because by reasoning we arrive at legal reason. No one is bound to give information about things he is ignorant of, but everyone is bound to know that which he gives information about. Yeah. Try to hold most people to that one. Not to believe rashly is the nerve of wisdom. Although some say it's a bit impolite to be skeptical these days, unfortunately. Many men have known many things. No one has known everything. What is not read is not believed. No man is bound to have foreknowledge of a divine or a future event. It is sometimes expedient to forget what you know. That might be part of the keys to the wisdom. It is necessary that given persons, lands, and estates should be comprehended in declaration of uses. And that makes sense. And it profits little to know what ought to be done if you do not know how it is to be done. Notice is named from a knowledge being had, and notice ought not to halt. An example, be imperfect. Right, now we're on to the good one here, land and real estate. See also homes, property, inheritance. An estate in free and pure allodium and an estate in fee simple absolute refer to essentially the same thing. What the original estate determines, the derivative estate determines also. Every entry on lands without the owner's leave or authority of law is a trespass. A right descends, not the land. Land lying unoccupied is given to the first occupant. That harkens to adverse possession. He who owns the soil has it even to the sky. An alien holds no lands. The shore is where the highest wave from the sea has reached. In no tenement which is held for term of years is there an avail of homage, but there is the oath of fealty, loyalty. Nice. We have a footnote for tenement here. So let me see if there's something here where there's a footnote for that. Tenement, land, buildings, offices, franchise, etc., held by the tenure. So the tenement is the land, buildings, offices, franchise, etc., held by another by tenure. So that's how they're using the definition here. So let's continue. In no tenement which is held for a term of years is there an avail of homage, but there is the oath of fealty, loyalty. Nice. Every person has exclusive dominion over the soil which he absolutely owns. Hence, such an owner of land has the exclusive right of hunting and fishing on his land, and the waters covering it. Water follows the land. A sail of land will pass the water which covers it. Water runs and ought to run as it has used to run. The situation and productiveness of the soil constitutes the value of the land. The owner of a piece of land owes everything above and below it to an indefinite extent. I know there's mineral rights, and then there's, of course, FAA regulations over lands here. So, I know this has been an area of contention here. Buildings pass by a grant of the land. Allodial land is that possessed by a man in his own right, free and absolute, without owing any rent or service to any superior. The law of God and the law of the land are all one, and both preserve and favor the private rights to the land. Whatever is affixed to or built on the soil belongs to the soil, whether attached by nature or by the hand of man. Whichever of the two parties has the division of an estate, the choice of the shares is the other's. Hanging fruits make part of the land. And gathered fruits do not make a part of the farm or realty. So we have hanging fruits make part of the land, but gathered fruits do not make a part of the farm or realty. Wow, that's interesting. All right. Glad you made it out here, New Normal. Grain which is sown is understood to form part of the soil. Whatever is planted in the soil belongs to the soil, either by the hand of God or the hand of man. Land comprehends any ground, soil, or earth whatsoever, as meadows, pastures, woods, moors, waters, and marshes. And at that, we're going to be leaving off because next time we're going to start again with law and laws. See also common law, law of nature, and rules. So I hope everyone had a good time tonight going over these great maxims of law, and everyone's going to be here for the next one. And the best way to know when that's going to happen is to, of course, hit that bell notification and subscribe to the channel, because it's going to be a nice expedition as we work our way to the end of this great writings of the old authors and preserve the knowledge of these maxims of law, and hopefully we'll have ways to express and act on the American jurisprudence and common law heritage of this land. So I want to salute to all of you. Much love for showing up tonight and carrying on the tradition of reviewing these maxims of law. Pretty soon we'll be through this whole book, which will be just a tremendous addition to our knowledge base of where we can start to have necessarily the rubber meet the road when we talk about the law in our lives. So on that, I hope to see you all in the next one, and peace out.